Yeah. Okay, welcome, folks. This is November 20th. It is our Joint Justice Oversight Committee. And we're going to start this morning with getting an update on the Chittenden County Accountability Court. This is a result of a conversation that the mayor of Burlington had with the governor in trying to address public safety issues, their homelessness issues, and the backlog within our court system as well. So there's been an agreement between the city of Montpelier, city of Burlington, and the governor's office to implement some targeted resources. It would be with the state's attorney's office, from the defender general's office, from the courts, as well as the pretrial supervision program, which was kind of a pilot project. It was done up in Essex County, has now been shifted to Chittenden County. So we really want to spend time getting the background of this, who are the dedicated folks, how that's going to impact your overall operations in the rest of the state. And keep tabs on this to see how effective this is, because I know that there is requests from other parts of the state that if they can do it in Chittenden County, why can't they do it in other counties in the state? So we'll start with the Tim Lueders-Dumont from the Department of State's Attorneys and Sheriffs. So welcome, Tim.
Good morning, Tim Lueders-Dumont from the Department of State's Attorneys and Sheriffs. And there's been a number of agreements, including a shared employee that we're sharing with the governor's office right now under a provision of law that allows for employees to be shared by multiple entities. That's Zach Waite, Deputy State's Attorney from Washington County, is also serving as the governor's special prosecutor in Chittenden County. And is working embedded in State's Attorney George's office and in the what we call 3B, the pilot docket, accountability docket in Chittenden County, but they just call 3B. It's just the courtroom where it's happening on the third floor.
3B or P?
3B. It's just the name of the courtroom in the Chittenden County Courthouse where they're holding the accountability docket. So if you are in Burlington and want to see the accountability docket in action, courtroom 3B is there. Judge Maley, Defender General's office, some private counsel, and Attorney Waite. And we are proud to sort of have our skin in the game. These are cases that the state needs to handle. And Sarah George's office and the office of the governor in this collaborative approach have worked really hand in hand. We're having weekly meetings between the special prosecutor, Zach Waite, Sarah George, myself, and the governor's office. And we've been into it about a month now. So the program really kicked off just about a month ago. When we were last here, it had been almost, I think, a week or so. So we've made some progress. I think both myself and the Defender General said it's a little too early to do testimony and some hopes and thoughts, but we have seen some real success. And at the end of the pilot period, which is supposed to end probably sometime in February, we hope to have hopefully some metrics working with the judiciary and the other partners about start date in mid to late October, end date sometime in February, and looking past just quantitative data, looking at things like the experience of victims and defendants and the attorneys and the judge in the process, as well as DOC, right, with the pretrial supervision program. Howard Center has been really helpful. So in terms of some initial successes and some of the context, what we're focused on is the high volume defendants. People with 5 or more pending criminal cases is the list that is ever changing, but is the list they're working on, and addressing both accountability for high volume defendants and in doing so also the case backlog. When you're addressing 5 or more defendants, you're also intrinsically dealing with cases that are getting older because of multiple pending cases. The first month has demonstrated, in my opinion, 2 clear strengths. One is dedicated, frequent, and flexible scheduling. So the 3B courtroom, the accountability docket, the judge can say in a more flexible fashion, I will see you next week. I will see you in 2 weeks. You have Howard Center waiting in the hallway. as opposed to our typical more crammed docket, which is the next time we can probably see you is in 30, 60, or 90 days. Your pretrial has not yet been set. And that's because at the same time, and there was a homicide trial that happened over the last few weeks, the focus in our other courtrooms is major felonies. And so the frequent flyer, nonviolent felonies and misdemeanors are now having a home in the Chittenden courthouse because of the dedicated court space and time. And so that frequency and flexibility of that courtroom helps you address violations of conditions more quickly, helps you address, I would say, expectations concerning when the next event is going to be. And the more frequent interactions with services, as well as with defense counsel, with the judge. Like, there's nothing that, in my opinion, imposes that accountability mindset more than interactions with the judge. We see it in treatment court. We see it in other instances. And so that has been a real key strength from a qualitative perspective. Another key strength that we're going to hear more about from others here, I would say, is the accessibility to clinical and supports immediately in and around the courtroom. So at some point at the end of this, hopefully Attorney Waite can come in and talk to you about his experience there. But until then, he's focused on the pending cases, and the governor's office can talk more about that too. But it's the whole wraparound. What is AHS being involved? And they are very involved. The Howard Center team, private providers. The Defender General has providers as well. I think in your committee, Madam Chair, the warm handoff concept. So not just go down the street and let us know how it goes in 2 weeks, but really someone right there, accessible, same day, is another key strength that is almost immeasurable. And we've seen some anecdotal positive stories where we're all project managing instead of emergency response. I've often come in here and say, the criminal justice system is an emergency response system. And this is more project management, social work oriented, with accountability also attached if people are struggling with the basics. Another key component that is overriding all of this is strong collaboration with multiple entities, including with the judiciary, having meetings between defense counsel, the special prosecutor, and the judge about scheduling, about priority, and having that very streamlined and consistent, I know has been a strength. And I want to say, objectively, Judge Maley has done an incredibly good job of managing expectations and also pushing on the gas pedal in terms of the pace in that courtroom. It's what we're hearing from the prosecutors. Sarah George's office has found a desk for Attorney Waite to sit in her office embedded. And this is another key component. Our existing administrative support staff and victim advocate staff from Sarah George's office in our department are providing the direct staff support to the special prosecutor. So we're in collaboration with the governor's special prosecutor. He's embedded in State's Attorney George's office, and they both attested to me of very strong working relationships. So the same victim advocates that have cases in the other courtrooms are also staffing the courtroom in the accountability court. And that's a very clear synergy and strength that I think we've seen across the board. And the victim advocates, and we'd actually asked them at one point, and this was all sort of settling out, and the airplane was up in the air and we hadn't quite fueled it yet. Would it be helpful if we tried getting extra victim advocates in here to help with this? And they said, these are our cases. At the end of the pilot docket, they'll be our cases again. We want the victims to have consistency. And so that's been an important piece, and the victim advocates in Sarah's office have done an incredible job staying attuned to these cases. Every Monday morning, the special prosecutor is meeting with the sheriff and with emergency response to talk about transports. So thus far, the sheriff in Chittenden County has been able to handle all of the transports that have taken place in the first month. I will say, as a projection in case it comes up, the first week of December, and I look at Judge Zone, there's a potential pinch point with pretrial conferences where we may need to call upon emergency management to assist with some of those transports. They may be outside the capacity of the sheriff, but we have a plan in place, in part because of these weekly meetings about capacity, where we may call upon other agencies to support with transports. It's also possible, as often happens with pretrial conferences get sent, the plea agreements start flying. So it's possible we won't have as many cases that need to be prepared for trial And some of those transport orders will hopefully fade away, and it won't be as much of a resource drain. But we'll know more in December about if that was a potential gap in the system in terms of if you were to expand it statewide. Pretrial supervision, I'll let DOC talk about that, how that's going. I know that was not quite ready day one, but it then was launched shortly thereafter. And our special prosecutor has been in constant contact and made multiple referrals to pretrial supervision. My understanding is there's one individual who is in pretrial supervision right now. And Matt, Defender General Valero, can talk about his perspective on that too. I know there's maybe some questions, concerns on the statute in terms of some exposure for defendants. And so I think we're figuring that out, if it's going to work, if there's improvements we need to make. And I know the judge at one point maybe raised some concerns about a couple of referrals as well. So the referrals are happening, the conversations are happening, and there's a dedicated DOC staff person that's up there ready to go. So that's good. The option is there, and hopefully we'll have some more information on that soon. Some of the key takeaways, and this may be something where in another month or two, I'll have even more information on this, but what we're doing right now is we're using existing resources. Right now, Washington County is without one of their prosecutors. Sarah's office is doing a great job of using existing administrative and victim advocate staff. So we're being very collaborative. We're using existing resources, but it is not the current system, even in itself, is not sustainable because Deputy State's Attorney Waite needs to go back to be a Deputy State's Attorney in Washington at some point in February. So that's something where the governor or the legislature wanted to expand. It's also not going to be one size fits all. So what worked in Chittenden would be different than what works in maybe Orange or Franklin County. Another important piece to analyze would be the existing potentially underutilized court spaces. If there are days where a civil courtroom or a family courtroom or a criminal courtroom in the other counties are available, can you push an accountability docket? Maybe not every day, but in some of the other counties. So that's an analysis that we would need to undergo. It won't be one size fits all. And I want to make that clear. The Chittenden example is hopefully going to be very successful, but it will look different in different counties if it were to expand. And as one state representative who also is a former member of the department, Representative Oliver said, this is maybe what should be happening in every courtroom if we had all the time anyway. So it's an example of best practice if we had all the time and we didn't have 120 or so pending homicides. So I thought that was a good comment from Representative Oliver.
So I can't help but weigh in. This is great to hear, but we did this once before. And we did it, I think it was around 2015, 2016, where we provided wraparound services right there in the courtroom. I think it came as a result of another piece of work we did with the Council of State Governments. And we contracted out with some providers to actually be in the courtroom at the time of the hearings and then hook the person up with that provider. So we've been down this road before. And I'm pretty sure it came out, I don't know, Matt, if you remember, I know they had it in Windsor County.
The Sparrow project.
Sparrow project. And then we stopped funding it and it went away. So we're reinventing something we've already done in the past. And I think it's great to do something like this. I think it should be done statewide. But I really get concerned. We take care of the problem. We put a Band-Aid over it, think it's fixed, and then we move on to something else. And 10 years later, we come back and do the same thing that we've done. So exactly what you've said, I agree with, but we did it before and then we didn't fund it.
Yeah, and one of the,
So I can't help but put that on the table.
I do see Senator Lyons.
It's my prop. That, we did this already. Then we don't fund it.
It was called the Sparrow Project.
Sparrow project.
It's actually still in the statute, but
Yeah.
it has no point.
Yeah.
It's not good.
Absolutely.
So,
So, anyway,
Alice, I have my hand up.
yes,
Thank you. And thank you for this report. The part that I'm was very interested in was the accountability data that you're collecting and how you're looking at the effectiveness of the project. I mean, obviously, it's different from what would have happened in Essex. And I think it's great it's happening in Chittenden, simply because of the volume of concerns that we have in our area of the state. Uh, your last comments, Tim, on expansion, how are you folks, and I include everyone who's going to testify today in this question, how are you looking at expansion across the state? So you have an idea of what the differences are in areas across the state. How, as what data, what information will you be looking at? And is anyone, including the courts, reaching out to other parts of the state to do an assessment of what would be needed to have that expansion? Because it seems to me, I mean, Alice's comment is important. We can't have a pilot program and then drop it like a lead balloon. We've done that, so many times in different areas. So what, and this is a general question. I'm sure that each person who testifies this morning may have some idea of what we can do to understand what's needed across the state. Is it an individual contract? Is it a governor's office contract? Is it a legislative initiative? What do we need to do? What data do we need to have to expand this, assuming that all the aspirations and all the information you've given is on target about success?
Yeah, I think what I'll do is I'll just take it in two parts on the metrics. And one thing I didn't mention is it's something I want to talk about at some point with both the Defender General, the Governor's Office, and Judge Zone, because for me, it's not just disposition rate, it's not just clearance rate. We need to dig a little deeper on something like this and look at reoffense rate, and we can pick apart what that means. But I'm just going to say it for now, but something like reoffense rate. How many of the folks that were in this pilot that went through it come back through again, and during what time period? And we'll use the common term recidivism, but we know that definition needs to be fixed in statute. The second one is docket resolution time. So from the date of filing or the date of offense, we could choose something, to the time of disposition or resolution of that case. Are we reducing that time period in this docket experiment? And as Judge Zone will undoubtedly say, some of these and many of these dockets, and as the Defender General knows, won't resolve until this pilot is ended. And so you can't actually test that all of the metrics within a 4-month time period, but we can start to the beginning data point. We know this docket started on October 20th. How long did that take to get through the whole system? And what was the outcomes? And then service completion rate, totally outside my realm and my lane, but something like, what does the success look like for someone that's been referred to different types of services? And how does that correlate to reoffense? These are three kind of key metrics: a reoffense or recidivism, docket resolution time, and service completion or service success. I believe they're all interrelated, but those are some things that are not clearly determined by something as simple as clearance rate. How many cases did you move? Is one metric and a helpful metric, but not the only one. In terms of, so hopefully that was helpful, Senator Lyons. The second piece I wanted to say on expansion is it's four key elements: more judge and court time that's more flexible, access to clinical support close by and right there, and then prosecutorial and defense resources. Under prosecutorial resources, I'll say transport resources too, because it's a part of the judicial system that is key for detained persons. So those are 4 key elements, really: judge and court time, clinical support, and service support, and then prosecutorial defense resources underneath there. A second one would be the types of, within the judicial piece, allowing the judges to calendar in the way that will best serve accountability. So instead of, and maybe that looks like a uniform scheduling order. Judge Zone and I went to a conference on what happens in some other states on this. And you think about scheduling orders for felony cases often. Murder case, okay, we got to get experts submitted by this state, depositions done by this date, you're going to have a trial next year. For misdemeanors that don't have experts and are maybe just retail theft, camera in the window type of cases, we don't think about scheduling orders as much. And I think probably we should if we want to have more accountability for the nonviolent cases. So something like a uniform scheduling order that says arraignment date, status conference, trial, last and best final offers in the case, really tight may help. Another piece from our perspective is if we were to do this in Chittenden, we know that an additional prosecutor thinking just about these cases, Jack Wade has no homicides pending on his docket in the 3B courtroom. That's really helpful. He can just focus like a project manager on those cases. The homicides are being dealt with in other courtrooms by Sarah George's office. So dedicated accountability staff would be helpful. In some counties, that will look like a dedicated staff person or dedicated person like we've seen with Attorney Wade. In other counties that are smaller, and I'm not going to use any by example because I know I would get in trouble for saying particular counties, but in other counties that are smaller, you might need a drop-in attorney, a regionalized attorney, a regionalized staff to drop into a smaller county once a month on accountability day or fast arraignment accountability resolution day. Drop in with a traveling judge or maybe the same judge and work on those cases and have a quicker response time. Violation day, accountability day, whatever would serve best. And it's not a dedicated staff person. Maybe, and I'll say maybe it's regional, and they could be working in a region, multiple counties. Likewise, if you're going to increase the speed at which people are getting to court, that means more transport orders. And so you would need more transport support to get people to say yes to more and more transports more quickly. And we don't have county jails here in Vermont. So that, I will submit at some point, it's a very large document, but our director of sheriff operations calculated how much time you need to get from each facility to each court, pretty much based on just using, Google Maps essentially. But on average, is what you need to account for. So we don't have jails 2 minutes away from each courthouse. So more transport staff and then administrative and victim advocate staff are important for the rights that we assist with concerning victims and with defendants. Administrative staff ensure that the camera footage, the discovery gets to the defense counsel. Pro se defendants in this population are some of the self-represented persons. There are some, and they're some of the most difficult cases to work with because I can't call the Defender General staff and say, hey, let's work on this. We have to get stuff in and out of the facilities, which creates its own issues for people who are incarcerated. For people who are pro se in the community, it's even more problematic because we don't know where they are. They don't have an attorney, and they are part of this population of repeat folks who are nonviolent. And they take up a lot of time. So there are some pieces there, and maybe they're working with services and they've haven't signed releases. So there are some pieces there, but the administrative, paralegal, and victim advocate staff, if we were to increase the speed that cases needed to be addressed, that means all of the things that we do need to happen more quickly. And that can happen either through more staff in our whole field or more centralized or regionalized staff to assist statewide. So that would be a policy call for either you all in terms of if the governor has plans on this. But that's a call that, if centralized or regionalized or putting more staff out in the field. But it won't be one size fits all, but really potentially more attorneys and more paralegals, potentially more transport, definitely more transport staff. And in my opinion, definitely more victim advocate and administrative staff.
So I'm kind of intrigued within the state's attorney's world. This is what I'm trying to weigh. Do we need more staff or not? And you're suggesting maybe more regional, but within the state's attorney's world and their current offices, if you had one state's attorney that was dedicated to the accountability, rapid resolution, would that free up time for the other state's attorneys in that office to do the work that they need to do? It doesn't get bogged down with these cases that you can kind of work through quickly so they can spend more time on the murder cases or whatever it may be. Would it
100%. 100%. It would help in part because right now the same desks have the homicides and the misdemeanor repeat folks and
a dedicated staff person in the current office for the misdemeanors would help with the overall workload of all the other state's attorneys in that office.
Yeah. And like I said, some could benefit from a dedicated staff person in that county, and some could potentially benefit from a floater or something like that. And some might also say, we need dedicated major crimes staff too. But it would free up more time.
So structurally, how you structure
Yeah.
your cases with the
Yeah.
staffing.
It would help.
I guess my question is, you know, is there the capacity within the existing staffing? You know, in some cases, probably yes, in some cases, maybe not, to do that restructuring, you know, to say, you know, with our existing cadre of 5 attorneys, you know, attorney 1 is going to, you know, concentrate on this, you know, rapid response, and, you know, the other 4 are gonna concentrate on these others. So it feels like, at least to some extent, that could be done within the existing staffing, just thinking outside of the box a little bit in terms of how cases are assigned and to whom they're assigned, and same thing on the judicial side, and thinking about, you know, how can we do that? Because then, you know, what you said, Alice, would also be true, because then that would be freeing up time for the remaining folks to concentrate on other things. And not saying that you could do that on a necessarily an ongoing basis, but maybe when the backlog gets to the point, you know, that it is now in some cases, that might be a more strategic use of existing staff.
Yeah, and part of it would be determined by, let's say we could free up a courtroom or some court time.
Mhm.
It would almost be interesting to test if you freed up that courtroom and that court time, and we're going to use the name of a county that doesn't exist, but Johnson County in Vermont doesn't exist. They have 4 staff, and right now everything's in one courtroom, and they're getting murders, homicides, misdemeanors, retail thefts, everything's in there. And they find another courtroom down the hall that's just doing this docket. You would want to test the existing capacity. In some counties, I would say that they might need more administrative staff, more victim advocate staff to help process that. But maybe they could do it with existing attorney staff. I don't know.
Mhm.
What we've seen in Chittenden is it was helpful, right? We know that there were staff that were going to have to deal with this population of folks that were able to dedicate time during this last month on more major cases right now. And so it would depend on the county. I know that's probably slightly frustrating.
No, it's
Yeah,
what
it
I
would
would
depend.
expect. It's what I would expect.
Yeah.
You know, I also know things are going to be tough in the next couple of years. And so I'm thinking, you know, that if there are sort of creative ways to think about this in ways that, you know, maybe we haven't necessarily done, or maybe they have and it hasn't worked. But I think we also need to be thinking about how can we attack this without necessarily adding additional staff, and that might be periodic borrowing staff from a different county.
Yeah, and the court time, and if there's courtroom and court time and judge time too. Whenever I'm saying that, I mean judge time as well.
Yeah, oh, yeah.
If we have more of that, then I think regardless, that's a good thing.
Mhm.
You know, in a dedicated space where the violent cases aren't filtering in and out of that courtroom. I will say there's been some violent cases that have filtered into this accountability docket, but they've been able to be addressed because they also have a bunch of other things pending. So that it hasn't been no violent felony shall cross this threshold type of rule. It's how can we address repeat cases and older cases and stuff like that. So it has come through, but it's a good question. I think I would want to think a little bit more about it depending on the county. Mhm.
Some questions? Gonna be some. So I have a question about the transports. This is Chittenden County doing this, and I'm assuming that there are women involved in some of these dockets, so that's pretty clear, the facility's right there. I'm assuming there's males that are coming in from St. Albans because the detainee population for males is held up in St. Albans. What other facilities are you seeing for transport coming? Are they coming from Newport? Are they coming from St. J? Are they coming from Springfield? Where are they coming from?
Yeah, I don't have the specific locations. I know there was an emphasis and conversations with the Commissioner's Office of Corrections on trying to emphasize the St. Albans location so that it's easier to get to and from. And if there is going to be someone that falls into this 5 or more category, that it be communicated with the court staff and the players so that they're aware of someone getting moved for whatever reason. You know, it could be medical, it could be safety, whatever the commissioner's analysis is. So we're having and this goes to the collaboration, and I should have said it, but we are collaborating with the Department of Corrections as well on a pretty regular basis on that. And so, again, Attorney Waite has functioned as essentially a project management on the executive branch side. And then the interface to both to the judiciary folks and then the other agencies. And so I don't know all the locations where people are coming in from, but the emphasis has obviously been on trying to keep them in Route 7 corridor. Maybe some came from Marble Valley as well overnight, but St. Albans has been the emphasis point.
So 5 or more cases that the person needs to have open. How many of the folks that are going through are out in the community and not being detained?
Yeah, so
And what issues are you seeing with that? Because they need to show up at court, and are they showing up?
actually quite a few folks, the reason that they're picking up more cases is because they're not detained. If they were detained, they wouldn't be picking up more cases, but basically this accountability court is driven at the onset in the first month by folks who are basically not detained. Some of them are being detained on 5 or more. There's maybe someone with a violent hold without and a bunch of other stuff going on. But during the course of this 4 months, there will be people that do not show up for court and have failures to appear and are then detained. And in our opinion, that does sometimes result, it's not the point, it can never be the point because it's about engagement with court, sometimes results in resolution more quickly. If they are detained, it also means the defense attorney can locate the person and knows where they are located so they can talk to them, and the transport sometimes effectuate that. It can't be the reason for the interaction, but we are seeing over this course of the next couple months upcoming, probably some folks will get detained and then come back through this court system with the 5 or more. And it's that daily snapshot is always the struggle with the detained population of tracking for trends. But you could, and I don't know the capability on this, again, start date of October, I forget what date exactly it started, through February, how many people included in this pilot were detained during that time period? It would be an interesting question that I don't know. I won't speak for the Department of Corrections on that, but be an interesting question. A lot of them are in the community at the onset, though. Yep.
Yeah, you had mentioned it's courtroom 3B in Chittenden. I'm looking at the calendar. Is it every case that's in 3B that is on this docket?
Yes, that's where yep.
The other question I had is, I don't know if they use Zoom or WebEx, but is there a link where we could watch? If you could send it to us, that'd be great.
Yes, I can.
At least we'd see what happens on the record. I know a lot of it doesn't.
Yes. There's a WebEx link. I think it's still WebEx there. There's some transitions going on with Zoom, but.
And there's no limit to the type of cases. It's just the number of cases.
It's the list they're working off as 5 or more. Yep. Okay. So it could, like I said, it could include violent cases in that mix.
Yeah, I'm looking at a fellow who's on probation for aggravated domestic assault.
And I should mention there are some
domestic
Rule 5 hearings, some probation cases that do come into there with 5 or more.
Tucker.
I'm going to ask this question, and I don't even know if the basis of the question is the information that I hear is true or not. Are there any reasons that people are recommitting these crimes based on the fact that people are talking among themselves and they're saying, don't worry about anything because we're going to plea bargain this thing down and you'll be out in the street. Now, especially Chittenden County, I hear all the time people, I don't even know Sarah George. If she walked in this room, I wouldn't even know her.
We'll have to get her in there.
But I know that's good, yes. But it appears anyway, from the street talk, that she's a very, let's say, liberal prosecutor. And things get plea bargained down. Does that fit into this thing at all? I mean, is that coming up like a person had this type of crime? It was plea bargained down, they're out, and then they recommit.
Yeah, and
Because they know nothing's going to happen except they're going to be told, don't do it again.
One thing I'll say is, Chittenden County has the highest number of homicides pending in the state right now. So a lot of the state's attorney's attention is on the homicide cases. They just completed one last week. I'm not going to prescribe liberal, conservative, moderate.
No,
et cetera.
that's why I
Yeah,
prefaced
yeah,
my question by, I don't know.
Plea bargaining, as one of your colleagues here knows well from Bennington, is a part of every case. And so there is often this analysis, and I'm speaking from my own experience as a prosecutor, where sometimes it takes the most serious case, like someone may have a bunch of nonviolent cases, and it takes that most serious one for them to get detained, have a real court interaction, a real court intervention, and a real serious conversation about resolution. And so sometimes what happens is we might dismiss retail theft in exchange for aggravated assault because it's the one that's the most serious case in the list, and it resolves the cases for the person. It's a part of, it is a part of daily practice. 99% of cases have a plea agreement. And I do think one of the things that we've heard anecdotally from some law enforcement in the area and from some of the Chittenden community is there seems to be some aspect of a bit of a change in tune and culture of, hey, if you get arrested and you're one of these folks on the 5 or more, you have to go to court quickly and often. And that we know helps with accountability, regardless of plea agreements happening or not. We know that coming in quickly, and if we're getting into court more often, you're less likely to pick up more cases. If you're going into court once every 90 days or 6 months, you're more likely, if you're in the community, Madam Chair, to potentially pick up more cases just because you're out in the community, you're exposed. If you drive on the road, you're more likely to, get a flat tire. So, if you are out in the community and you're picking up more cases because you're not seeing a judge until 6 months later, that's the problem. On the plea agreement piece, each case per law has to be looked at individually. But sometimes it is a violent case. I don't know if you're getting at that, but a violent case sometimes can help resolve, or a more serious case, the other ones below. And we do sometimes dismiss less serious cases in exchange for the violent conviction. Yes. Yeah. Hopefully, was that helpful or?
Well, it is to a certain extent. What is the cooperation between the local police departments?
I think it's
How is it on this particular thing that we're trying?
Chief Burke in Burlington, who has appeared in front of you before, potentially the Chiefs Association, formerly of South Burlington, has been in communication with Attorney Wade in this project, and has his own essentially, frequent interactors, folks that he interacts with a lot in Burlington. And my understanding is law enforcement is working well, including there's a special retail theft program with the Chittenden County Sheriff, and engaged in a few big box stores in Chittenden County, and there is some aspect of deterrent effect that I think, but the law enforcement folks could come before you as well and talk about maybe what they're seeing culturally, or in terms of the mood on the street, as you said. But they've been at the table and they've been very helpful, including state police has been really helpful in Department of Public Safety.
That's the thing that I would like to see, that kind of information come out of this, because I hear from police departments that cases that go before the state's attorney, they're dismissed. And they're out in the street, and the morale in the police department is down because they keep seeing that same face. They arrest them, and then the next thing they know, here they are again. They're in trouble again.
Yeah, and I think part of the helpful point of a specialized courtroom is that rapid speed, rather than, if I'm, sort of law enforcement, if they have regardless of location, we know this is an issue statewide, but let's say here in Washington County, right, we have someone that is repeatedly breaking into stores in Montpelier and Barry. To get them to trial, sometimes it takes a very serious case for it to jump the line.
Yeah.
And so law enforcement, I think statewide, has begun to really understand that arresting someone for the low-level cases, it takes a really long time to get through the court system. And so I can understand, regardless of state's attorney's action, depending on the county, the morale could be impacted by just the pace of the judicial system in general, because the judges are also having to prioritize the most violent cases. But I will say morale for judges, for state's attorneys, for defense counsel, it may be a similar feeling of, man, we're never going to move this case until something more serious happens. And also underlying all of this, I could be a whole nother conversation, but the mental health side of these cases, those have their own spider web of complexities, which make everything much more, much less timely. So throwing in mental health into one of your examples there, if someone found not competent, that is a really difficult hurdle to climb. We do not have funds at our department to essentially contest competency unless it is a violent case. So unless you killed someone, our department is not funded to contest competency.
Thank you.
Martin?
Yeah, just a bit of a follow-up from Representative McFawn's points and questions is my understanding, and I want Tim to confirm this or not, is, a lot of these individuals are out pending having a trial. They're not able to be detained because it's not a violent crime, so they can't be detained without bail. And they can't have bail imposed because they're not going anywhere. They're not a flight risk. So they're out on the street until they actually have a trial and have a plea bargain. And it's during that period of time that there can be repeat offenses. And there's lots of issues to help these individuals. They often have housing challenges, substance use challenges, mental health challenges. But as far as with respect to the criminal justice system, the whole idea is to have speedy and certain consequences. And that means having the court hear these cases quickly and that all comes down. And we've only kind of hit this a little bit that I think what this, I'm going to jump into something else, but Tim can comment on this, but it comes down to resources. We're seeing an injection of resources that we don't otherwise have with respect to the clinical support, with respect to the prosecutor, the court, et cetera. And if we want to be able to do this, maybe we can shuffle the chairs on the deck a little bit and I hope that we look at each county and see if there's something we can do with existing resources. But we've been looking at this for years, and certainly the last 3 years particularly, and have really understood that we need an injection of resources. And I think that's what this pilot may prove. So there's two things there that I said, Tim, if you could comment on those.
Yeah, I think going back to your comment and also Representative Oliver, who's not in the room, and I'm quoting now twice, but ideally, this is how courts would work generally if we had the time and if we didn't have a backlog and we didn't have a major uptick in violent crime over the last 4 years, 20 plus homicide victims over the last 3 years on average. And we're still getting out of what happened in 2022, which was nearly 30 filed homicides. So we're still getting out of those cases. At last I checked, there was 19 this year. So that's a major pressure on the system, which puts pressure on our ability to have court function more normally in our unified system of having repeat cases happen more aggressively. I know that depending on the judge, this has been a priority. I know up in Orleans County that the judge up there has taken time to put some emphasis on this issue. And I know that in some other counties as well, that they've done good work on this to clear their repeat cases. But ideally, this is how we can have court function on a daily basis. On the second piece, on the resources, I would say the number one determinant factor is the space and time with judges. And then from there, we can see where the resources are needed. But right now, we'll do a December data analysis of judicial filings, but we still have, just under 400 cases per prosecutor. And you've heard the story, 600 cases per victim advocate. And for administrative professionals, it's about 800 cases per administrative professional. Cases coming in, they work with law enforcement, get cases filed, et cetera. So yes, it's two-prong really. If we have dedicated space to move more cases, we can reduce those caseloads. But right now, we don't have enough time to project manage those cases. So we're in a feedback loop. that's why this docket is really an incredible gap analysis to see whether it's transports, whether it's court time, whether or not a prosecutor doesn't have 3 homicides that are staring at them for the next year. The emotional space to work on individual cases and think about individual defendants more socially and more service providing, that type of contact is just, I was thinking about my own caseload, and I remember I had a couple of homicide things pending, some aggravated things pending, but if I just had space and time for these types of cases to project manage, and then have time with service providers to have a weekly meeting on whether or not we can get people to court. Time we don't have enough of. And that is the number one issue we could solve for, with some staffing, yes, but also with efficiencies in our system. Part of that is us being creative, even in this, sitting around the table of 3 branches of government. Yeah.
And top.
Yeah, quick question, and I'm not saying I want to preface this by saying, I'm not saying that our special prosecutor needs oversight. I'm sure that he is more than capable of handling this position. But having said that, I'm curious as to, does the special prosecutor's position have clear carte blanche on plea deals and whatever else, and he does not have to run this by anybody, he just makes that?
That's my understanding. He is the governor's special prosecutor. So I would let the governor's staff answer to that in terms of this pilot program. But my understanding is yes.
I'm not saying I don't have a problem with it. I'm just curious. Thank you.
That's my understanding. Yep. And that's my observation as well. When I did observe court in Chittenden County in the 3B accountability docket, and he appeared to have carte blanche, as you said.
Topper?
Has anybody completed the process in Chittenden County? Has anybody that has completed reoffended?
Yeah, and this, I'm looking at my notes here. I really think that's one of the most important metrics to test, because even right now, let's say you were arrested for something, you came through, you pled out, you had services, and now you have housing.
Yeah.
I would want to see whether or not you reoffended between now and February or the end of the program.
Yeah.
There are people that have had convictions and services provided and working at the table with defense. There are people that have gone through all the way,
Yeah.
and the test will be whether or not they come back.
But so far they haven't.
There may have been some that have, and I would want to look into that more to see whether or not they have. And again, I think having Attorney Waite come in and speak to you and someone from the governor's office at the conclusion of this, using judicial data and maybe some law enforcement, like you said, just on the arrest data for persons, that would be a very interesting piece as well to see, regardless of what happens in the court system, whether or not someone was rearrested during this time period that went through it would be another important piece from the police agencies.
Yeah. Thank you.
Martin and then Rob.
Yeah, this is a follow-up actually to Senator Norris's question. So as far as I would assume, well, I'm hoping that the special prosecutor is completely independent. Wouldn't there be some issue if the governor's office had any involvement in determining whether to accept a plea agreement or any involvement in determining what cases should be tried? It should be completely independent, shouldn't it?
So the last time this happened was when Senator Leahy was the state's attorney in Chittenden County, when they appointed a special prosecutor. And I forget the name of the individual, but it was because there's a case on it, a persistent repeat offense and backlog in Chittenden County. And I forget the year, but it was when Senator Leahy was the state's attorney. So you should bring him in. But my understanding of the council provisions that the governor may appoint is, they're the governor's supervisee. And, Jay Johnson's the governor's counsel. She'd be the best person to answer that. But, looking back at that case that I've read, and we could definitely provide the individual, the way that any prosecutor works, who is the chief of the entity of which they are operating. So whether it's a state's attorney or the special prosecutor, they operate best when they have the ability to work in the bounds of the individual cases.
So could you provide the citation to the statute that provides for this and that case? That would be helpful. Thanks.
Yep.
Ron?
And Tim, Hopper just talked about, they get through the entire program, they're done, they're off the docket. If they come back, is there a mechanism in this docket where they go right back before the same judge, and so that same judge will be seeing them again?
Yeah, I think that they're talking about what that looks like, and we'll probably know more maybe next month if we have had someone who's reoffended or been rearrested, and then deciding whether they go to the other courtroom or the 3B. So that will be my personal opinion. I've just outsider cheering from the sidelines of this on this program, which I very much support. But I think they should probably go back to the court and see Judge Maley again if they can.
Going back to the same parent.
Yes, Madam Chair.
So I appreciate what you said, that under normal circumstances, without court backlog, this is how the court should be operating. But there's two additional tools that have been added. One is the connection with direct services. That when you have someone from the Howard Center physically sitting in the courtroom, where the person, the defendant, can then go right to that person and set up an appointment. Where in other counties right now, here's your phone number, here's the phone number, give them a call. So it's a hard handoff instead of just, so that's one tool.
Mm-hmm.
The other tool, because there's 5 cases or more on the docket, they would qualify for pretrial supervision out in the community by DOC. And those conditions are set by the court, but it is DOC that is now supervising that person pre-trial in the community. We don't have that in other parts of the state. And that was put in specifically to address public safety. So if there's a violation of those conditions that the court has set on this person, the person hasn't gone to trial, hasn't been convicted or anything, it just has charges to him. If there's violations of any of those conditions that the court has set, then DOC will then go back to the state's attorney and say there were some violations here. Then it's up to the state's attorney whether or not to pursue that with court. So that's another tool that is just there for Chittenden County, that is not there for the other courts. So I just want to put that on the table, that those are 2 important pieces.
It's something that could work well with pretrial-esque approaches is, again, getting them in quickly if there's and again, when I say violation, I'll break it down. It is a prosecutor has found probable cause for a violation of condition of release for someone on pretrial supervision. It is another filing for a crime. And so that DOC notice to the state's attorney probably looks like an affidavit, like a police affidavit saying they didn't show up, they didn't do this, they didn't do that. They violated the conditions set by the court, and I'm supervising them. They're presumed innocent. And so the violation is another filing, and unlike other spaces where they're getting pushed out by the violent cases in Chittenden, they have an opportunity to bring it right back in and say, hey, there's been another PC affidavit filed concerning a new offense. Let's talk about what's not working in the past week.
But it may not be a new crime. It's a new offense where they violated the conditions.
Which is a crime, which is an alleged crime.
Be a crime?
A VCR, yep. Just think about it as just a regular violation of conditions of release. They just happen to be on pretrial supervision. Yeah.
Jenny?
Thank you. I'm I'm actually invoking my role as vice chair here and thinking that we have an hour left and 4 other folks
Right.
to comment. So I'm wondering if we could listen to the other testimony on this, because we're getting into a terrific conversation. I don't want to lose that. I think just having the rest of the folks testify at this point, and then we might be able to move into a broader discussion. This is very helpful.
And Tim, you do have a hard stop, so I was conscious of that.
Thank you.
Thank you, Jenny. So, thank you, Tim. We appreciate it. So right now I'd like to shift over to the defense.
And if the conversation gets broader, Attorney McManus from our department will be here, ready to jump in as needed.
I'd like to do the defense next, and then we can get up to the before the judge. So Matt, you're the other piece of this,
I'm one of the other pieces.
one of the other pieces. So welcome.
Well, thank you for having me. I felt after the last couple of times that I was, had multiple dockets and was trying to get court time here.
Yeah.
Sat around for 2 days. But now I'm here. So you're going to give me the treatment, I guess. I'm Matt Valerio. I'm the Defender General. Happy to answer any questions about this. I will tell you in general what we've been dealing with. First, let me say that the kind of the branding of this thing to me is, it annoys me. This talk about an accountability court as though the rest of the courts aren't. It's not really right. What we've done here is something very simple. We have segregated a docket. So I call this the multiple misdemeanor docket in Chittenden County, and that's what most defense counsel talk about it, because when they're working in all the other courts, they feel like those are accountability courts as well. And no law has changed. So we're applying the same law regarding bail, regarding the criminal law. Nobody's rights have been waived regarding the right to trial or anything like that. But the simple part of this is we have more resources for another judge for 4 months. And we have apparently some designation of resources for the special prosecutor, which is good. And within my office, we didn't get any more resources, but we also didn't ask for any more resources because bottom line is all these people are already represented. All these clients are already represented by lawyers. So the only thing that's going on here is the thing that the lawyers, defense lawyers, always wanted, which is, can we get these darn cases into court? Now we can, because there's an extra judge, there's a designated prosecutor, and the one big thing that is a little bit different is this access to various AHS resources and designated provider resources when somebody comes into court. Now, what I've done is I have segregated an amount of funds and designated an organization that we work with somewhat regularly regarding cases involving mental health, substance abuse, co-occurring disorders, and the like, and have that person on call and available every day, or that business on call and available every day in Chittenden County. The DG's office didn't get any more money for that, but the way I look at it is rather than piecemeal dealing these on a case-by-case basis as they might come up in the regular docket, I'm just kind of consolidating those funds into this docket with these people, with the idea that if we can make sure that AHS follows through on the promise of services for these people, and that is what, that's what doing our job is. We also have to make sure, and these folks are licensed mental health providers and also have access to people who, for both co-occurring disorders, mental health, and substance abuse, and to make sure that these folks are actually being referred to the right kind of treatment. And most importantly, that they actually get there. So literally, we have the folks who we have under contract are driving people to where they need to be, making sure they get to their appointments, making sure that if they're supposed to go to a screener designated by AHS, that they actually get there and see them. That is something that wasn't happening before. because there was not a consolidation of effort on these particular types of cases. One of the biggest reasons you see these cases sort of build up is they just sit there. They don't go to court. So the longer you're sitting around waiting to go to court, the more likely it is you're going to pick up other charges. So from our perspective, we have just redesignated resources to focus on this court now that there is a court to focus on. Other states actually do some different things with regard to misdemeanors. They have courts that are just misdemeanor courts. When I was, now it's 40 years ago, but when I was in Massachusetts, yeah, I know. When I was in Massachusetts, they have the district court there deals with misdemeanor cases, and you have your trial rights and all of that there. And then if you're charged with a felony, they have something called a bind over hearing to determine whether or not there's facts sufficient to prove a case beyond a reasonable doubt to send it to Superior Court, where you handle all your felonies. So you got a bunch of folks who basically just handle misdemeanors, and then there's other folks who handle felonies. And so the misdemeanor docket is always big, it's always backed up and the like, but at least there's a light going forward as to what you do. We don't do that because traditionally, honestly, we really haven't. We've had plenty of volume, but we haven't run into a 2+ year pandemic that basically closed the courts from trials that has kind of put us behind the 8 ball. And then coming out of it, we've seen a bump in crime in various counties. So, there are things that feed into this. I've heard a lot of testimony over the last couple of days, last month and this month about, defense strategies and that kind of thing that have caused issues with resolution of cases. Honestly, the testimony's been from people who have never represented a defendant in their life. They don't know what defense strategies are, and there is no defense strategy. We represent individual clients, and when clients decide they don't want to take a plea deal, then the case waits until it can get to trial or a motion hearing or the like. That is one of the fundamental rights of defendants to decide whether or not they're going to resolve a case. Now, we know that it's about 98.5% of all cases resolved by plea. They don't go to trial. Honestly, without that, you'd be in a world of, trouble, shall we say. The system couldn't handle it if every case went to trial. And these cases are no different. And one of the things we see with the multiple charge co-defendants is that they typically do have substance abuse issues, mental health issues, and the toughest ones have co-occurring disorders, so they got both. And those folks don't always think rationally when they are, they're not, with all due respect, they don't go out in the public and say, no one's going to do anything to me, so I'm going to do this. They aren't thinking that. They don't think that far ahead. They don't think that is not part of the rationale. That's what like a rational person would say is, well, if I take this, nothing's going to happen. But, if you've got a drug problem, you got a mental health problem, that processing isn't what's going on. Now, to a rational person looking at it, you go, that must be what they're thinking. But that isn't what they're thinking because they aren't thinking. And so when we get these same folks coming into court, what the good thing about it is, if we can get them screened, if we can get them hooked up with the type of services, we get them to the point where they can make rational decisions about the resolution of their cases. And that is the key to all of this. When you don't get into court is when you have problems, when you don't have access to these. And I'll say one other thing, because there have been a couple of sort of poster children for the problems in Chittenden County. Both of those individuals were people that hundreds of police interactions, dozens of court cases, and both of them had co-occurring disorders, which Vermont has no facility in the state, none whatsoever, to address. There are no facilities in Vermont that deal with co-occurring disorders. The public defense system, through the company that we work with that deals with these types of folks, got them into treatment in co-occurring disorder facilities in New Hampshire. Part of the big issue there is whether or not they could establish residence in New Hampshire so they could get it paid for by Medicaid. This company assisted us in doing that. And our office was able to get them help. One of the individuals I spoke to, now it's a few months ago, was very lucid and was doing very well. The other one apparently is also doing very well. But when you can hook these people up, and it's not always guaranteed forever, but when you can hook them up with what they actually need, as opposed to just say, here's an order, you're supposed to get this treatment. When you can actually drive them there, get them to the place, get them hooked up with the treatment, you have a chance. And so what this court does with the resources that are available to everybody in the system gives us a better chance of doing that. And that is the key to all of this. Just like it was the key to the Sparrow Project in Windsor County 10 years ago. That was a little bit different because it was a high risk, high need kind of thing. It didn't distinguish between, there were some cases that were excluded, but it would take violent offenses as well. And this one is doing that to some degree. That is the key, to be able to provide that opportunity. And then there are some you're not going to succeed with. So, I think that this is a good opportunity. How this rolls out statewide, I have all kinds of issues about the way I reorganize. If I was the king of all criminal justice, I have all kinds of ideas of how I would do it if I were on the prosecution side, if I were on the court side, but I'm just on the defense side. So I've done it the way I do it. And what I've done is I've designated 2 of my existing public defenders, who all of these cases already being represented by public defense, to focus on this court when they come up. So if one happens to be in the other court, on one of the other courts, the other could fill in. Now, we have 2 parts of our system. One is the staff public defense system, which is the staff office. And then we also have our contractors who deal with conflicts. And we have cases spread among them, but they represent about 25% of the people in this court. The 75% are in the staff office. So it's less intense for them, but it's probably more annoying for these contract lawyers, because they often have contracts in multiple counties. And they also have a private practice that they run beyond the part-time contracts that they are dealing with. Even if their contracts are, we talk in terms of LECs, lawyer equivalent caseloads, as opposed to FTEs, full-time employees, but think of it in the same way. So these contracts are 0.6, 0.7, but they have 40% of their time, more or less, that is devoted to other things. So they're not always immediately available to just run the court, but the court has been accommodating in dealing with those, and the 75% of the cases that are in that court have come in without any particular problem. I don't know how. It's been 3 weeks. I mean, this was. We haven't had a chance for this to marinate. Forget about complete. The 3 weeks in the judicial system is less time than I just took saying 3 weeks in the judiciary. It's not enough time. You can't judge or talk about what's being successful or not successful. You know, when we talk about recidivism, usually the recidivism rates are, you know, have you been charged with another crime within 3 years of that? And if you go out 4 years or 5 years, you know, recidivism rates would look much worse. Eventually, a lot of people come back, but it's like 20%. What I mean is, you know, you have 80% of people who come in the criminal justice system, and then you never see them again. And then you have 20% who come back a lot for a long time, between the age of like 18 and, you know, 42, I think is the number. So, you know, I'm happy to answer any questions about how we look at this or rollouts across the state and all of that kind of thing. I've been just really focusing on what was kind of presented to us in Chittenden County. And I think it does present an opportunity, and we're trying to work with it while doing the job that defense lawyers are supposed to do, which is to make sure that the state lives up to its end of the bargain.
We do have some questions. So Tucker and then Jenny.
Matt, with all due respect,
Mm.
as you said to me, with all due
Yeah,
respect.
that's one of those things where, you know.
Yes, and I know what it is. 38 years working in human services.
Mm.
I can tell you that we have to be very careful about statements we make. When we make a statement like, none of these people are thinking about that. Thinking about that, meaning if I offend, nothing's going to happen to me. I can tell you from firsthand experience, personal experience in those 38 years and the time that I've been in the 20 years I've been here, I have personally heard people that told me that don't worry about it. Nothing bad's going to happen to us. So we have to, they are thinking of that. Not all of them, and the 20% or whatever it is, maybe that they were part of the 20% that reoffend. They don't care. I understand what you mean about thinking straight if you're on drugs. I understand all of that. My experience is when people were in treatment, were trying to get clean, and that's when they made the statement. So they weren't, well, I don't know if they were, I don't live with them.
Mm.
But it's happening.
I would
Whether
agree
that causes them to do it or not is that's another question. But I agree with you.
You can't make a universal statement. I
agree. That's the point I was trying to make.
agree with you.
But I think you both are saying, once a person can get into the appropriate treatment, then they start to realize what is occurring in their life and the consequences to their behavior.
I mean,
Until,
honestly, the guy I met with a couple of months ago, he was like, I can't believe what I was doing. You know, he's like, I'm so ashamed of what was happening. I don't like the way people think of me. I don't like the way people look at me. You know, I will never have any reputation again. I basically have to get out of here, kind of thing. But that was somebody thinking lucidly, you know, you know, it was actually very refreshing to see, even if it's one person, you know, for now, we're able to help one person for now. Now, I don't know what's going to happen 6 months from now or a year from now, but you're right. You know, and that's what I said. The big opportunity here is engagement if we can do it.
then it's.
And just getting the cases in front of a judge.
Do we have another question here, Jenny?
Yeah, thanks. And thank you, Matt, for your comments. Obviously, having community services is key, and this, perhaps this experiment will unfold with what gaps we need to fill, where they are. Having Howard Center there is important. We know from the the judiciary and mental health work that's going on at the Supreme Court, we're learning about the need for not just mental health and substance use disorder, but we're also learning about the need for behavioral health counselors in our state and recovery centers and so on and so forth. So your comments are just well taken. I'll leave it at that. But as you're going through the work with New Hampshire or with some of your clients, it would be helpful to know what are the specific behavioral health needs that are lacking and or mental health co-occurring gaps. We see them all the time, but so I'll leave it at that because I know we've got other folks who can comment on this area.
I'm happy to, you should actually have Crystal Berry from Therapeutic Works in Burlington come in and talk to you. She's the one who has been doing the work for us. She won't talk about individual clients, but she could definitely talk about the work that they have done and the success that they've been able to assist us with in getting people successfully into treatment and what they do. There is this kind of gap between being ordered to treatment and and number one, it being the right treatment, and number two, getting them there when it occurs. And that would be a good person for you to talk to.
Thank you. And then another comment, I think, which is just a general comment, since this is an executive branch contract with the court, it seems to me that we're hearing a lot about what resources we need. And that it sounds like this is and as you've said, it's just a change in how the court does its work, but there are implications for the resources needed to make those changes, whether it's in one area or across the state. So it would seem to me that I will look forward to the governor's budget and how it expands or not this work, knowing that it is the governor's budget from which we begin our evaluation overall. So I'll leave that at that.
I'd like to add too that we're lucky that this was rolled out in Chittenden County from a defense perspective. Because that is, it's our largest staff public defense office. They handle 39% of the state caseload. I can, in an office of 11 or 12 lawyers, depending on how many are, if I have a vacancy or not, I can allocate one or two lawyers to focus on a particular docket. If this were, well, an easy one would be if this were in Addison County, I have one lawyer there. Then I would need somebody else. If this were in a smaller county, it does implicate different resources. Some of the bigger counties, and you might not think of them as particularly big relative to Chittenden County, but like the Rutland, Bennington, Wyndham, and Windsor, for example, are all sort of the same size. And Franklin County is also sort of these 5-6 lawyer firms. It becomes more difficult to allocate, a person away from other caseload to do that. So I think the rollout, if there is going to be one, presents more difficulties in the less populated counties. And there are counties where our primary public defense offices are contracts. Very similarly, that poses more difficulty where there are not state employees in those particular areas. Now, I've been thinking about this and ways to address it, but as of right now, there's been no proposal whatsoever, as far as I can tell, to expand this anywhere. And I'm just focusing on Chittenden County.
Questions? Because I know we got to move along here. Any Thank you, ma'am. I'm sure that there's gonna be a lot more conversations of this once the session starts.
Yeah, well, you know where I am.
Yeah.
So thank you for having me in.
Judge,
That's nice. Thank you.
we'll get into DOC.
Good morning, Tom Zone, Chief Superior Judge. If I can, just very quickly leave this topic for 1 minute and say that you began this morning talking about the young man to my left, Ben. I view it somewhat like, let's talk like parents to children. You know, we know how our kids are at home. And so you're like the parent. You know what Ben's like when you deal with him. And then they go out in the real world and you wonder, are they behaving? Are they doing the right thing? I just want to tell you that from my perspective on my side of the equation, he has been an absolute pleasure. He has served you very well. He has served the citizens well. And he's not only is he very talented, but he's a really nice guy. So he's going to be missed.
I agree.
So
Thank you, Judge.
you've had a lot of questions today, and I could give you a big prepared speech, but the reality is, I think what we've heard about time, space, resources, that's the essence of the opportunity that we had here. The executive branch, the governor, had an idea about trying to devote additional time, space, and resources. He brought the players together, the stakeholders. We talked about things. The program was put together to try to highlight these dockets. And frankly, from the judicial perspective, that absolutely aligned with what we were doing anyway. I know Rep. Lalonde knows that I send out copies of the 5+ to the judges and say, we need to look at these cases. We need to move them ahead. And this program, it's people keeps calling it a program. It's a docket. And I appreciate Mr. Valerio's comments about the term accountability. All of our courts are accountability. This is the 3B pilot docket, multi-case docket, whichever of those terms people are using. That's how we view it. Because it's really, we're not having any different law. We're not having any different judges, if you will. We have a judge, we have defense attorneys, we have prosecutors. Everyone's coming in and doing the work that we would be doing in the other docket, but we have the devoted time to be able to look at these cases that need to have the time to address them. And more importantly, what do we also have? We keep hearing about it, the resources. If you have the ability to do, I think Mr. Lueders-Dumont, Tim talked about the warm handoff, people in the courtroom to be able to utilize those resources, that is very beneficial. And the idea about what we're going to do after this pilot in other counties, I don't think we're going to have all the same resources, whether it's the state's attorneys, as we've heard, the defense bar, the other type of resources for community services, for treatment programs. We're not going to have all those resources. And so my perspective is that what we need to do is say, okay, what have we learned here that we can use in other counties with our available resources? I am aware that money is going to be tight. Tim gave you the example of Johnson County. And if we did a Johnson County program, so you'd have to fund a new judicial assistant because it's a standalone courtroom. We have to have security. We have to make sure we have an extra judge to pay. We have to have transports. We then have to have a public defender. We then have to have a state's attorney. And then we have to have the community resources who are willing to be there and support it every day. That's not realistic for every county in the state. But what is realistic is to take the lessons we're learning here for Matt, Tim, myself, and to go around and look and say, okay, what can we do in these counties? Can we set, even in the smaller counties, can we set one afternoon every week or every 2 weeks that's going to have these cases? The attorneys were going to be dealing with something that afternoon. Let's make it focus on this case. What we know is that when we do something like that, if we're focusing on these cases, then there's other cases we're not focusing on. But that's the nature of the judicial system. By focusing on these cases, we can hopefully resolve them. And let's see, have we had success in this program, in this docket so far? And people will have differing views on what success is. There were no metrics set out at the beginning to talk about recidivism rates and what the term recidivism actually means for purposes of this docket. No metrics set out for programs. Do they have to complete the programs that they go to? But what we do know is this: since it started, there have been 18 defendants cases that have closed. There have been a total of 152 separate dockets for those 18 defendants. I'm told that as of today, there are 87 defendants whose cases are in the docket. Out of those 87, 28 are on arrest warrant status. So now we're down to 59. So there's 59 individuals in Chittenden County who are in this docket. Another question that was asked earlier was how many of those individuals are incarcerated? I'm told that the number is 34, and 4 of those 34 are in federal custody also. So there's looks like about 25 people who are out in the community, and the others are incarcerated. So that tells us when we talk about needs, the transport need is significant to get the individuals to court. Again, the resources are significant. And these are things that if we bring these out in other counties, can we work on a system that says, okay, in Windsor County, we're going to make sure that work with the Department of State's attorneys and sheriffs that anybody who's incarcerated on a 5+ case every other Thursday or whatever date it might be, we're going to make sure we can get transports and we're going to have them come back to court, or we're going to get them into court to see what we can do in those cases. Those are the types of things that I think we have to look at. Again, it's a function of what can we learn here? And what we've learned so far is that if you give these cases the resources that we would ideally like to give every case in the state, it can lead to different outcomes. And it can help us move the cases along at a more timely level, because that's important to the defendants, that's important to the public, and that's certainly important to any victims. So I wish I could sit here and say, okay, here is the exact plan for what we're going to do now going from here. But I know that I think literally as we are sitting here, I think it's the special prosecutor, the defense attorney, and the judge up in Chittenden were meeting to talk about this very type of issue for Chittenden County and what it's going to look like going forward. And so I'll be visiting with Judge Maley after that, and I'm sure that Josh O'Hara will be getting back to Mr. Valerio, and the special prosecutor will be visiting with Tim, and we'll have a better idea of what they think. And then we can get together and start saying, how do we do something different? Judge Morrissey up in Orleans County has, the past 2 months, has been calling in the 5+ cases. I know Judge Tebow up in Orleans had done it. I think Judge Treadwell had done things like this down in Brattleboro, Judge Corsones. And so we do have areas where this has happened. And the goal, from my perspective, is to try to, we'll say, formalize that in the counties to try to take advantage of what we're learning here. So any questions, happy to address them.
I've got a question that's not really connected to the resource per se, but I'd like your take on the pretrial supervision in terms of how you see that playing out within Chittenden County. It's now, Chittenden County is now the pilot sort of for that particular initiative.
I was one who believed when the pretrial supervision came out a few years ago, I thought that Chittenden County was the place it should go anyway, because it had the most resources. It had a lot of numbers to deal with in cases, and I just thought that was the place. But I understood why it was being rolled out somewhere else. As I understand it, it's being utilized. I think the last number was 6.
There have been 4 referrals and 1 person just in it.
Okay. So they're now sending people in this direction. And you may recall, I think it was the special prosecutor, Mr. Waite, I think he sat here and said that it wasn't for everybody. And so that those numbers sound very consistent with what he was expecting. I think that program, if we have the potential to roll it out in all the counties, first of all, the small counties deserve the same programs as the big counties. We should be uniform geographically to the extent that we can to provide opportunities for defendants and to provide mechanisms for public safety and tools for judges to be able to utilize when we're dealing with cases. So I think if we could roll it out everywhere, it would be beneficial. And if the numbers in Chittenden that's not a staggeringly high number. And so I don't know that it was something that would be 20 or 30 people at every court. I don't see that. So I would think that it's something that could really help. That was thought to be a public safety measure that provided part of what this docket provides, and that is the assistance to get timely resources to assist the defendants with their needs. And so if we don't have the ability to have that resource sitting in the courtroom like we do in Chittenden with people in there for the warm handoff, and the best we can do is a pretrial supervision program to have that assistance, well, it's certainly better than having nothing. And it gets us one step closer to getting people where they need to go.
Questions? Thoughts? We gave it all to Tim.
That's okay. So, well, thank you. If you have any questions going forward, let us know. And certainly as we have ideas for moving forward about what it's going to look like both in Chittenden and outside of Chittenden, I'll make sure to keep you informed.
Well, this will be a topic of discussion once the session begins in many committees, and there'll be more information at that time. That's really a couple months away. Thank you, Judge.
Thank you. Have a great day.
Yes, well, you're gonna be back this
That's
afternoon.
right. I'll see you at 1:30.
Yes. Let's see, well, both folks, come on up. There's another piece of this was, and we're only dealing right now with WellPath, which is the contract that DOC has to provide healthcare, mental health services within the facilities. The trial supervision is also through DOC, where they supervise the folks out in the community. But the focus right now within this pilot project is to really look at folks who will be involved in the MOUD program while they're incarcerated that have gone through this specific docket. And also we wanted to have the feedback from you folks in terms of how is that going to play out in your world, but also you're going to see mental health and health issues related as well with these folks. So we wanted you in to talk about that, but I'm sure we'll also probably expand into talking about WellPath and healthcare services and corrections in general. It would be my hunch, because we've tried to have WellPath come in to do a little deeper conversations in terms of healthcare being provided in our facilities. So Dr. Euliger, if you could start, introduce yourself and go from there.
Yeah, sure. Thank you. So Jim Euliger, I've seen most of you before. I'm our statewide medical director for WellPath. I've been serving in primary care and addiction care in Vermont in one way or another since 2004. I'm thrilled to have Shannon Rogers, my partner. I'm not going to say partner in crime, my partner, my colleague, who, in several of my previous testimonies, I've done a good attempt to bring some of your expertise on your behalf, but I'm thrilled to actually have you here. I'll let you introduce yourself.
Thank you. Shannon Rogers. I'm the Director of Recovery and Reentry Services for WellPath. I'm a duly licensed therapist. Prior to this work, I worked in the community designated agency within the hubs. Previous position, I was director of the BART in St. Albans. I feel really fortunate to have the opportunity to do the work that we do in this setting and the way that we do it. And thank you for having me today.
So are you, Dr. Euliger, you're based out of Waterbury,
Yes.
out of the central office for DOC. Are you also, Shannon, based out of
Yes.
Waterbury, the central office?
For WellPath, separate.
Right, for WellPath, but you're based there. You're not in the facilities per se.
I travel to the facilities frequently, yes, but I'm centralized in the regional office.
So all the medication, the medical treatment for opiate use disorder and other use disorders that I supervise, Shannon really presides over the other part of what recovery is. And obviously we have significant overlap, but so that's why it's been so essential to have her here. Thank you, Chair, for giving a frame to the pivot because I was listening to this conversation for the last almost 2 hours, and it's fascinating, but kind of we're going to bring a slightly different perspective. And feel free to move us if you're receiving something different than you thought. But really, what I hope to bring is our perceived ask from the governor in terms of what we're being asked to do in relation to this whole project, and kind of what that means for actual care on the ground. And I'll say, first of all, we're thrilled. Like, this is a wonderful ask. I'm thrilled. What we've been asked is to have another level of care for opioid treatment in our facilities. And for those of you, I think you have there's varying knowledge about what that might mean. So I'd like to give an analogy. At my primary care office in Heinsberg, when I practiced there, we treated pneumonia. We treated pneumonia in young people who had a cough for 3 weeks and maybe felt a little warm, but their temperature was normal. We also treat pneumonia in the hospital if you're older, if you're sick. And then we also treat pneumonia in the intensive care unit. So we have different levels of care depending on the nature of that pneumonia. The same is true of opiate and other use disorders. We have different levels of care. Some people get buprenorphine in their primary care provider's office. Some people have intensive outpatient treatments where they get seen every weekday. Some people are admitted to facilities for residential or more inpatient care. So we were asked for a long time, since 2018, we've had medications for opioid use disorder in our facilities, thank goodness. But we've really had one level of care. And people would come in needing, say, intensive care unit level treatment for the pneumonia, that is their opioid use disorder. And we had the office level care. So this is exciting. My concerns are about the resources, and it's really two. The resources it's going to take to deliver that, and we've been vocal about that, and we've been getting response, and it's, the people have been responsive. And then what the integrity of delivering those services is, and I'll explain what I mean by that. So the primary, as you can imagine at any place, it's people and space. Because higher levels of treatment for opiate use disorder require more frequent contact with clinicians for therapy. So whereas for somebody who comes to our facility in opiate withdrawal, we treat them with buprenorphine, they meet with our case managers periodically, they see the provider again 3 months from then. It's a very long, it's a long period of time to go. And they may get some treatment for the mental health disorders. For the various levels of opiate use disorder, there's 9 hours and up, and I think Shannon has some more, but there's several hours per week. We might be meeting with the provider every week. We might be getting urine drug screens more often. We're having therapy, we're having groups, and this is something that to have the space and the people to do that is the biggest barrier. I think there was
When you say space, is that physical space?
Physical
in the
space.
building?
Yes. So I'll give you an example in our facility at Northwestern. Right now, the case manager for our patients for opioid use disorder uses whatever desk when somebody's out of office for the day. That's where he meets with people because he doesn't have a place to meet with people. And if we're going to ask for 9 hours of contact per week or more, depending on the level of treatment, we need physical space. And and I can, without getting into the weeds, so we've had conversations about space. We've had, we've met with many people throughout the DOC, the superintendent at that facility, but that's just an example. And then we need to hire the people to do it. So we do, and just to give you an example, we want to make sure people who are assigned judicially to a certain level of recovery services are clinically appropriate for that. So we're going to need to do some evaluations. We do plenty of evaluations now, but who's interpreting? We don't necessarily have somebody in place to interpret currently it's like, yes, you have opioid use disorder, and yes, you're appropriate for medication. This is a more nuanced evaluation we need to do. So who's going to do that? Who's going to supply the 9 hours of treatment? Who's going to do potentially the increase? We've talked about co-occurring disorders. So say a substance use disorder and a mental health disorder. Now, obviously we have mental health treatment, but to really do both the same in an intensive outpatient way is going to require more people.
So that is the goal, where you just laid out more intensive treatment,
Yes.
MOUD as well as therapeutic, more holistic
Yes.
for the folks who are going through this specialized docket.
Yes.
So what the judge just said, there were 33 folks who are detained that would be available or would be required to go through this elevated. Are they all in St. Albans or are they spread throughout your system? Do you know?
That's part of the problem. That's part of the issue is that we don't know who these folks are and who's responsible for assessing them at this time. As of yet, we have yet to assess any one of these individuals for this court.
How do you not know who these individuals are?
Well, I guess, and with your forgiveness, how would we know? I guess is my question. I
The
think who,
DOC must know.
um,
And then the information isn't getting to WellPath? Is that what's the
So-
breakup is?
so the program, one of the challenges is, so this, I heard about this first, I don't know, I think 6 weeks ago. And so this is to stand up a program like this is like a 1 to 2 year event. And we've been at it for 6 weeks. And when I spoke to Secretary Samuelson, I loved it. She said, I want a minimum viable product. And I'm very good with that. Like, let's get something rolling and then we can build. Fine. But one of the things we've been talking about is what are the contact points between the court, the DOC, and WellPath, so we know who these people are, and that just hasn't been built yet. And do you have anything to add to that?
No, I think that sums it up.
So that communication needs to happen.
I'm just curious, I mean, I don't know, from my perspective, doesn't matter. I mean, I think that what we'd all like to see is that individuals who need the assistance that you're talking about, doesn't really matter why they're there or
Well, now
how they arrived.
Yes.
It's you know, you're trying to treat the disease or illness or condition that they have.
Yes,
Yeah.
and you're singing our song, and I think but I also think that's a longer term goal, practically speaking, because the ask has been to set this up at the women's facility at Chittenden and the facility at Northwest, and to have a certain finite capacity because there's a footprint and a number of people involved. So we would need to know how many people are we putting through this program. And for us, I would love to do, this is called the ASAM, the American Society of Addiction Medicine Levels of Care. I'd love to do an assessment, an ASAM level of care assessment on everybody who came through and figure out where to plug them in.
Exactly.
I would love that. That's a longer term.
Yeah.
This is the reason we need to know who they are, is that's who would be funneled at least initially to the program.
So I know we got some committee members. Tucker, did you want to weigh in or not? Because we also have Mark.
well, yeah, I want to say one thing.
Yeah.
You said you didn't know the people. My question is, you knew this program was going on, right?
Well, as of 6 weeks ago, when we got the ask to set it up,
I'm-
yes. As of about 6 weeks ago,
Yeah.
when we received
So
the ask to
you,
set
so
it
you
up.
know, so what have you done in those 6 weeks to ensure that the work that you people are doing was part of this?
Yeah, well, a lot. It's been a lot of work. So, and Isaac can speak to it too. And so we've been meeting a couple times a week with our DOC colleagues and with the Department of Health and maybe the Department of Mental Health. We've come up with a new matrix of here are the new positions we've had. We've been talking about here's how much space we need. The DOC hired a consulting group. We went to the sites with the consulting group to look at actual space.
So you're doing things.
Have a lot,
Yeah,
a
okay.
lot of work.
Because you left me with the feeling that nothing was being done. You said you don't know who the people are. How would we know who they are? So you're doing things to set this up.
Absolutely.
I
Okay.
think Isaac may want to weigh in.
Yeah, please, Isaac.
Thank you, Chair. As David Paul's Manager, Department of Corrections. I just wanted to thank Dr. Woodridge and their team because there has been a Herculean effort to build this very, very quickly. And as the doctor said, this is a program that takes, in most cases, a long time to build these kind of systems, especially for the department, which is this is all brand new. We've been really focused on the pharmacological agents for the last several years, but we're really building now an entire treatment framework scaffolding, and that's new to the department. So there has been an incredible amount of work. We have an 80-page document that I think we'll be submitting to the legislature as part of our report on, the treatment program that we're building. And it's, the court, as Tim said, as the judge mentioned, it's relatively nascent. It's only been in existence for a few weeks. So we're still building out those pipelines for how people move through the court system and into this treatment system, because that's entirely new. So that's work that's ongoing with the prosecutor. And I would say in general that WellPath is agnostic as to the legal status of the folks they treat. So for example, oftentimes WellPath doesn't know whether someone's a detainee or a sentenced individual. Because they treat, to Chair Wood's point, they treat everyone the same. And that legal status, has really no bearing on someone's level of care. So what we're doing, I don't think the electronic health record even records someone's legal
It does
status.
not.
So that's work that we're also doing on the 1115 waiver front, different conversation. But what we're doing is relatively novel. And so what we have to do now is, I think there's work that is ongoing, to really bring together the federal prosecutor, the judge, defense counsel, the DOC staff, and WellPath. So you can imagine there's a lot of parties at the table. So we're building out those referral pathways and how exactly we identify individuals moving through this court, how they come to us, and how we make sure they're getting the treatment that is being built at this moment.
Okay, one other question, Madam Chair. When are you planning to finish that?
Yeah, I think we're hiring people as we speak, we're finding space, and I think that is a really incredible point. As the doctor also mentioned, our infrastructure, I think this will come as a surprise to no one in this committee, is incredibly limited. So we are currently trying to find and build out space that will allow us to do a lot of this therapeutic work that we haven't done historically.
In the building.
Physical space in the building. As you can imagine, Chittenden in itself, we have now between 170 and 180 women there on any given day. We're working through some maintenance issues right now with TGS. We do not need the physical space to accommodate. A lot of them, when you talk to our recovery coaches, and they'll tell you, right, and you talk to Tracy down in Rutland, we're doing recovery coaching in the dining hall, because that's the only available space that we have, which doesn't really lend itself well to confidential conversations about someone's substance use. So these are all the things that we're troubleshooting. And to your point, Representative, I hope in a number of weeks we'll be able to move people through the system more efficiently, but it's a work in progress.
Just to add two things, and I agree with everything you said, the system has been built so we don't know who is there for whatever reason. It's that there's insulation there on purpose so that we can just treat everybody the same. And I had another comment I forgot.
Everything's at the same level. And that's been made.
Well, and that's part of the problem.
Yeah.
Yes.
We have some questions here. So we have Martin, Jenny, and then Teresa.
So I think this is a question, and it's a kind of a higher level question of, shouldn't the individuals that we're trying to deal with, shouldn't they be getting treatment not in the non-therapeutic environment of DOC? All this effort to bring up or have more treatment in DOC as opposed to orders of hospitalization or an actual therapeutic environment. The whole thing kind of concerns me. That's all. And maybe that's as much for the rest of the committee as for our witnesses. But I just need to kind of put my perspective out there that I'm just troubled by the increasing focus on sending people to incarceration for treatment.
I have three short things so first of all, thank you. I couldn't agree more that there's nothing like less therapeutic sometimes than a detention center or facility. The second is that, and I'm not expert in this all, but we do have, I believe, some systems of court diversion or whatever. And this committee, I think, would be more knowledgeable about them than I are for treatment, people who agree to treatment. And then I think the third thing is this, and it's been my assumption, it's hard to mandate people to be in an inpatient facility, to mandate, we know it's difficult to mandate people to get psychiatric care. And the DOC is a place where we do that. Now that's outside of my expertise, but maybe this is one of the appropriate places. I'll leave that for all you to decide.
Well, I'm also wondering too, I mean, the folks are already there with you.
Yes.
I know what Martin is saying, but right now, those folks that are in this special docket are right there under DOC supervision.
Well, I think.
And the other piece that's rattling around in my brain, I don't know what you need updated statutes to do this in terms of delivery of MOUD in our facilities, because we're trying to do that last session, just to do some basic updates to reflect what was happening, and I couldn't get it out of my committee. So we're gonna need more in-depth. I hope I can get it out of my committee because the statute doesn't reflect what's currently happening or what is being proposed to happen. And that's something I'm concerned about. Jenny.
So you've touched on my comment. It's more of a comment, and it's also a question. First, thank you for your work. I know Wellcraft is just really, you're in initial stages of taking over all of the healthcare work for DOC. Our goal has always been to have access and provide care for folks who are incarcerated, consistent with what folks are getting outside, even though, we can't extend Medicaid, we know that. So my question is, if that's the goal and we're working in that direction, I'm trying to understand how this program puts so much more pressure on you. Is it, or is it a matter of all of the pressures in making this type of care accessible? That is it a co-occurring issue, I guess, for you? So I'll leave it there because I know there's a lot more to this, and our committee hopefully will have an opportunity to work with others on this in the session. So thanks.
Do you have a thought?
Yeah, well, so Dr. Uliger was explaining that ASAM levels of care, and currently, if we look at what we're doing to reflect the work in the community, we're looking at it like an ASAM level care one, like designated outpatient, designated agency outpatient level of care. So folks have access to medications, therapy, case management, psychiatric management, like in the way that an independent person would in the community. I think the ask how the ask for us is to offer a level 3.1 a residential IOP level of care, which really increases the amount of, and like Dr. Uliger said, touch points with the patients. So they're looking at, 9 hours of treatment a week for a certain amount of time. We're still building this out. So does that look like 6 weeks or 6 months? And we would need a protected space to be able to do this meaningfully, not just on the fly, not just on hallways and sally ports and if we think about how this is done in a community, those are protected spaces, structured spaces. So I think that's where we're really working to work through all these barriers and challenges, but those are the really real pieces to providing this meaningful level of care.
I really appreciate that, Shannon. Shannon's so right. I love the word meaningful. And there was this word integrity I talked about before. I don't want to meet this level 3.1 level of care on a technicality on paper and then say that and what's relevant here is that I don't know that we have these people. That's been not clear to me, that whether they're with us already or not. So if we're bringing in people to prison for treatment, I don't want to have a 3.1 level of care that's phony, phony, fake, right? It needs to be real. So there have been discussions, and rightfully so, when you're setting up something this fast. Hey, we already do this. We could count this. We can count that. Fine. But we have to do something meaningfully different. We're getting people into prison for treatment. It has to be a real thing. And so that's in my role as the medical director, I'm not going to say, yes, this is 3.1 level of care just because we sort of cobble it together. So for Senator Lyons, to really do this right, like we do in the community, we need space, time, people.
So to bring it to this level of care, the goal was for these specific folks that were going through the specific docket that were in a correctional facility would receive this heightened level of care. You don't know who these folks are. So are you doing this level of care across the whole system? So everyone who is medically necessary to receive MOUD, you would then realize that there's different levels of care. And you would do it for everyone who's incarcerated, or just these 33 people you don't know who they are?
That would be the goal, that we are not limiting people's access to care based on certain programs that they're in, that we would be able to offer this across the state, but they would need to be assessed appropriately with an evidence-based tool, that is, it's being consistently used, to determine if they're appropriate for this level of care, because it's also, it's not going to be appropriate for a lot of people, because that's a lot of, you need to be able to do that 9 hours of treatment every week. You need to be able to do it in a non-disruptive way, and you need to have the to be, think of level, stages of change, and where you need to be cognitively to be able to, so that they need to meet criteria for this level of care, which is pretty.
I have different levels of care for the 60 or 70% of our incarcerated folks who currently are on MOUD.
But I'd like to ask.
Or SUD.
Yeah, I think my understanding is that these people would be identified as they come into the facility. This idea that they're in our facilities, we happen to see these people a lot. Who the people, I hate using that word, these people, but whoever they end up being, they're identified at entry, right, Isaac, is the idea?
Yeah, just a couple points to share. I think, we are contemplating that planning a phased approach. So this is kind of phase 0, the immediate phase, as we're working with the accountability docket or 3B docket to get it up and running and identify these folks and, whoever is remanded into our custody to get them that access to treatment. But there are subsequent phases that would involve spreading this out to anyone in custody so that anyone who has the appropriate level of care can screen into that. And then the third phase is something we've talked about in your committee about potentially designating an entire facility that would be a more treatment focused facility. That would be a later phase. But that's all what's being contemplated. And we've been working with our consulting partners. We got money last year from the legislature to do that work. So we have that plan and we're building towards that. But I do want to just clarify one thing as well and be clear that from the department's perspective, right, we're not thinking about this as people being incarcerated for treatment. We are thinking about this as an opportunity for those that are remanded into our custody to receive a community level of care. And I think that's very important to point out from the department's perspective, that we're working with WellPath that if they are in custody and they are assessed as having a diagnosis of mood use disorder that warrants a certain level of treatment as dictated by the medical provider, we want to be able to provide that service. So we're not thinking about how the courts are moving people through this or prosecutors. We're really thinking about for those that are in our care and custody, how do we make sure they're receiving the appropriate treatment so that they can go out and be successful in the community?
Right, so, I mean, thank you, for saying that, because one of my, I guess, big questions and following up on Representative Lalonde and Senator Lyons was, I'm not hearing people say that people are being incarcerated to receive treatment.
That's right.
They're being
Okay.
incarcerated because there's some other decision that's being made about their, whatever, the legalities of it are. And if they happen to have substance use disorder, then they have access to this treatment. And what I'm hearing is that they're trying to have more offerings for treatment, not just sort of the vanilla version. So I guess I just wanted to be clear about that because, there were a few comments made by colleagues that felt like people were being incarcerated so that they could receive treatment. That's like, in my world, people saying, well, I have to go into DCF custody in order to get any services. Also not true.
Right, it's a supplement, not a substitute.
Okay, thank you. That wasn't my original question. So my original question was, if somebody comes to a place, comes into the correctional system, and we've been talking about MOUD and the various levels. Do you have a place for if somebody's decided, okay, I want to get sober? I want to go through this process. I know it's gonna, take some medical oversight during a period of time, and then there's other supportive services that are needed after that. Do you have the capacity to do that, or is that part of the capacity that you're developing?
So when you say sober, do you mean?
They want to go through detoxification. They want to discontinue use of
anything, including buprenorphine or something?
Well, I'm not a medical expert about whether that includes buprenorphine or not.
Yeah. Well, so we do have the ability to do a supervised detox. We would give you buprenorphine and you would, we could taper you off buprenorphine. And and that's appropriate for a very small number of people, to be honest, because the return to use rate is very high. We have 1 to 2 people per facility on naltrexone rather, which is basically doesn't treat your cravings, but so you're sober, depending on how you use the word. For most people, the time to be off of buprenorphine is when you've been stable for a while. And I would argue there's almost nobody in our custody who is stable for a while. Yes. Do we have a place? So I think is there a place? I would say no. Do I have a place? No, I don't know that any.
It doesn't sound like it.
No.
Big desks and cafeterias.
No, for them to be, do we have ways to support healthy decisions? Absolutely. Do we have ways how do you deal with stress when you're not going to use? Yes, we do that. We do a lot of, and it's going to have to be relearned out in the community.
Yeah.
Yeah, we provide a lot of education and around folks who want to discontinue their medication, around the risks, specifically for this population and release around lethal overdose. So we really want them to have a really good informed understanding of that while they're with us. We recommend that folks think about that once they're out with a community provider and work with a community provider if they want to continue medications after that really risky, dangerous period post-release, and they get more established in the community. However, this is a voluntary treatment, so if they do really want to discontinue their medication, we have them sign up. We actually have them. We have them sign a consent form that they understand the risks, and then we really want to encourage them to engage in case management, relapse prevention, other recovery services that may be in the building, like NA or church group, like where really plug into Because that's actually, for folks who are tapering or discontinuing the medication, they need more services. They actually need a higher level of care. I know a lot of times people are like, oh, they're all set, they're ready, they want to get off it, so they're good now. And that's just really dangerous. So we really try and encourage them to engage at that time and check in with them frequently. Thank you.
We have another question, Martin, and then Topper.
Yeah, first of all, I appreciate Isaac Dano's point that he made. But I guess looking at this docket, for instance, that these individuals are incarcerated, they're being detained. It seems to me just overall the approach should be to treat the mental illness and the substance use disorder that has led to the offense, and preferably not in a incarcerated setting. I mean, and I know that we do have some when you get to the point of a sentence or a plea bargain, we can divert individuals to treatment outside of DOC, and that's certainly preferred. But my concern is looking at these individuals to see, and I don't think we have that yet. That's part of what the courts commission is looking at is how can we earlier, before sentencing, be able to send somebody to treatment. That wouldn't be DOC presumably. So there's no question there. I just wanted to clarify kind of where my concern was, and I do appreciate Isaac's input on that.
Topper?
Yeah, thank you. When a person goes through the system and is incarcerated, when they come to the facility and they have a medical need, that's where I thought you people came in. So I'm having trouble. When you say you need space, you need this, you need that. I thought that was what the contract was that you signed, that you would provide the mental health needs, you would provide treatment for that.
Absolutely. That's what absolutely.
Yeah,
That
absolutely.
is what we do.
But if I could give you an analogy, so, and this is analogous. So the analogy would be, we were contracted to provide an outpatient office space to treat pneumonia. So I have the ability, the resources to give you antibiotics for pneumonia.
Yeah.
You come to me and you need hospitalization. I don't have a hospital. I wasn't contracted to provide a hospital, don't have it. So
Why would you sign a contract
well, that's,
if you don't have it?
Well, wait a minute here. Your facilities have infirmaries, but
Yes.
they're very small.
yes.
But if you need hospital level of care, they are not treated in our facilities. They are transported to a hospital.
That's right. So that's why it was an analogy. This is a different level of care that we have been than what we have been contracted to provide.
This is what I want to get at. It's a different level of care. When you signed to provide the medical care for people, I thought that included everything that you could possibly do, unless you had to go to a hospital or some other place, just as you would treat any other inmate.
Yeah. And
what you're saying is this is different.
And I'm not expert at all in it. Thank goodness it's not my job to be in the weeds with the contract. But that is not the level of care the system has been built to provide. There's a different level of care that we're proposing that I'm thrilled to build. Isaac, do you want to add to that?
Yeah, I think, and I also want to defer to my colleague, Nina Cheva, who could probably add more, particularly on the contract piece. But I think it's important to distinguish between programming services and infrastructure. So we actually did create a contract addendum to add additional services to meet the governor's substance use initiative, which is what we're doing here. So we built out the services piece of that.
Did they sign that contract?
Yeah, that's it. That's a contract that's on top of our existing contract with WellPath. Yes. So we created an addendum that would capture the increased programmatic needs that WellPath is delivering. There is, however, so that's flexible, right? We can plus up on services. What is more relatively inflexible are our facilities, which the last one, as the chair knows, was built a quarter century ago, and that's our newest. So, and if you take a look at Chittenden, our female facility, which I like to talk about because it's been in the news a little bit as we've been trying to replace it. And that facility was built really, 60s, 70s, and it was right now optimally can house 88 individuals. Right now we have about 100 more than that living in the facility. So we are really struggling, as we've talked about a lot over the last few years as a department. But how do we meet the increased needs of the folks who are in our system? I think the Department of Corrections and our contracted healthcare partners are caring for the sickest Vermonters. But we are consistently working against the constraints of our infrastructure because it was never designed to meet that need. We have more than, I think 2 or 3 hospital trips on average a day. We have our infirmaries, which were designed, Springfield is 10 beds, the largest one we have. It is full consistently. We have people who are aging in our facilities who are very, very sick. And so that is where we struggle as a department, is how do we meet that need? We can add services, adding more physical space to deliver programming and treatment and counseling. That is very difficult.
And I completely understand what you're saying. My problem is, why would we sign a contract to perform certain services if we knew we did not have the facilities to provide them?
We are working on trying to, find those resources.
I get all of that.
Yeah.
But do you see where I'm coming from?
I completely agree. At the same time, I think, we do have a responsibility to deliver a level of care to folks in our system who need it, understanding their incredible constraints. That's what the Department of Corrections and our staff face every day.
I mean, your person who's incarcerated, they're on average on what, about 10 different medications?
Yeah,
Five? 5.5, so it has gone down. It goes up a little bit. Medication, I mean, they're coming in with heart pressure, cancer. I mean, everything we experience, that's what DOC is experiencing, and that's what WellPath is to provide, is
And they said
medical
they
care,
could.
but it's not hospital care for folks. It's your daily medical care that the average person would receive. And we would receive it through a doctor's office or through home with prescriptions.
So, and I think maybe I would, and I heard Isaac mention this a little bit, and I think I would emphasize this. Our staff, to their credit, are expert in outperforming the care of the resources, how they're resourced to provide. I don't know if that makes sense. They give more care than I could expect them to, given how they're resourced. They're very good at that. When we're approached by DOC and the governor's office to provide a different level of care, for that to be successful, I didn't want to say, well, okay, we'll just work harder, we'll try harder. The thing is, well, here's what we need. And our DOC partners have been very supportive in that. Here's what we need to deliver this level of care that you're asking for and to be successful. And that's what I'm trying to be very transparent.
And to the doctor's point, I think the department's been very clear. When we come to this building and we say, we need a new facility. We need a new women's facility. So we have been very clear. At the same time, we think, to your point, representing your question, why would you do this? Well, what happens if we don't?
Oh, that's great.
Right, we deny individuals the care that they need, which is also, is not only immoral, but also violating the Eighth Amendment.
And we'd be sued.
And
Lawsuits. I mean, this is a real in-depth conversation for that. So in terms of the 3B docket and DOC's role in that, because it was to expand the use of MOUD for those folks who are in our correctional facility as detainees, basically. WellPath is really grappling with DOC in terms of how to provide this, and not just for these folks who are going through this particular docket, but you have to do it really almost system-wide.
Yeah, and I would add.
And then my question on that how does that impact the contract and the cost? Because how much are we paying right now to provide MOUD services?
Yeah, it's one of our most expensive medications, and it's not just the medicine, but that's the easiest cost to track.
And
How
it,
much is it costing?
It's still into our overall cost, which is about 40 million a year.
and those folks that, whether they're coming in for this program or any other reason they would come into us, they all have access to MOUD, and we try and treat them as timely and as appropriate, medically necessary, as possible. So that piece, I don't think that shifts or changes for anybody for this or for anything else. Like, that's our intention and our goal is, this life-saving medication, medically necessary, as timely as possible. I think that the complication is the amount of touch points needed for a residential IOP level of care. And how do we fit that in with someone who's a detainee with no known, this is a significant program, a formal structured program. We can't just on the fly do a couple weeks of intensive treatment. That's not, I don't know that would be successful or meaningful to of what the ask is and the intention of what we want to do to support these folks be successful. That's, I think, where the rub is.
Because a detainee, you never know how long they're going to be there. A sentenced person, at least you've got some indication, but in terms of your record, you don't even know who's a detainee and who's a sentenced person. It's based all in terms of what is medical.
We provide the same level, the same care to everyone. Do the right thing for the person who's right in front of us and what they need.
That time. Tougher, and then we've got to really.
Yeah, we gotta get it. Madam Chair, what I'm hearing, this is my own opinion. What I'm hearing is we've got a wonderful program, looks good in the headlines, etc., for a certain population of those people that have 5 or more offenses. What we don't have, what we did do, is set ourselves up for failure for the people that are incarcerated at this juncture. That's what I see happening.
Yeah, what we've got right now is your level 1 across the system. What was being asked by the pilot project is for those specific folks who are in our facilities that, and it's 33, from what we've heard from the judge, will get a more elevated MOUD program.
Exactly.
That's what's being asked. Question is, from DOC's viewpoint and WellPAC, how do we do this? Because we don't know who's a detainee, we don't know who's sentenced, we don't know who these 33 people are.
And we don't have the place to do it, or the resources to do it. That should have been done when the program was set up. This whole part of it should have been done.
So just to respond, Representative, I appreciate that. And it's something we're actively working through. I think to editorialize a moment, I think we've seen this before where it's oftentimes, it's easier to set up some of the judicial and prosecutorial mechanisms. But I'm thinking about, work crew, I'm looking at Chairwoman, where some things might work really, really well or faster, cases can be resolved, disposition, but when it comes to the correctional piece, that takes a little bit longer to work out because it is very complicated about how you keep someone in custody, how you deliver care, and those mechanisms just take longer to develop.
Yeah, and I'm hoping that you're able to do it.
We're working on it every day.
And I know, I'm not worried about you working on it. I know you are. I'm worried about it.
And it's going to be a conversation this coming session, because you're going to need changes in statute in terms of how the MOUD program is carried out in corrections. And no one's talking about that, but that's going to need to happen. And if our WellPAC contract right now is 40 million for the whole medical, mental health, and MOUD's a portion of that, that's going to be more pressure on DOC's budget. And DOC is funded strictly, usually, with general fund dollars. We have very, very minimal federal dollars coming in. So if there's budget pressures within the Agency of Human Services for general fund dollars, DOC is a place to look for general fund dollars, but then we're asking DOC to provide more service. And we have a contract with WellPay. So, we're going to be dealing with this next session, and I would really encourage the respective committees, Human Services as well as Healthcare Committee, to reach out to DOC and have these conversations, not just the Corrections and Institutions Committee. Because this is providing healthcare to people who are under our custody. They are under state custody. We have a legal responsibility to folks who are incarcerated.
I'm curious, what are some of the conversations that are going to happen around the status and how it is, or like what are the concerns that are brought up or the direction that folks are? I probably not the place or time. I
What was brought up
apologize.
today? Just what was brought up today, and how do we go forward with this? And if we're gonna do this triage, office visit versus more residential, and you want to implement that across all your facilities, we got to make sure the statute tracks that, but also where's the funding going to come from? Those are the issues that are going to be talked about during the session.
But don't stop doing what you're doing.
Don't stop doing it.
I'm relieved to,
Yeah.
that this is on your radar. It feels, because we're trying to do the work, but it would be great to have that.
But it would be really good to go to other legislative committees besides just the corrections one, so people can start understanding the delivery of healthcare in our facilities, because everyone thinks it's just similar to what we experience in life, which is to a certain extent, but to other extent, it may not be. And that's where you, DOC, is dependent on our healthcare system in the community. Because we use that. We got a break for lunch. It's 12:30. Thank you.
Thank you.
Thank you. And we'll be discussing this again. So we're running late. What's new? Like to see. I'd like to come back a little bit after 1 o'clock, like 1:10.
1:10.